Highest Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. We are on the record in CV20 0643. This is Hurn v. Cumbria. A couple of housekeeping items as we get started. You'll notice that as a panel we're physically distanced from each other. I see that neither of you are wearing masks. That's fine. If you were wearing a mask, I would let you know you're welcome to take it off if you'd like during argument. A couple of things to keep in mind. These proceedings are being video and audio recorded and live streamed. So we ask counsel to please identify yourself and your client at the beginning of argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock, and I think it's here on the middle podium, if you'd like to reserve a time for rebuttal. Also, please keep in mind that we've read the briefs and have conferenced the case this morning. And with that, counsel, you may proceed.
Thank you. Good morning. May it please the court, my name is Mary Kay Grenier, and I'm here on behalf of appellant Charlene Hurn Rutilla. She's now married and has a different last name. May it please the court, I would like to save 5 minutes at the end of my opening remarks for rebuttal. I requested this oral argument on behalf of my client, in part out of the passion that I feel that the court got it miserably wrong in this case. And in part because as a practitioner and as a practical matter, we are faced with discussing the issues with our clients as to whether an upward deviation applies in any particular case. And I cannot tell you in 26 years of practicing law, 23 as a family law practitioner, I don't think I've ever seen a case that more exemplifies the dictionary definition of what is needed for an upward deviation. For whatever reason, this court, the lower court, was fixated that this was mother's third request for an upward deviation. It was fixated on the fact that $2,600 and some change for child support is enough. It was fixated that any additional monies that the court may order in addition to guideline support would somehow go to mother and not the children. Why is getting an upward deviation in the Superior Court so hard? Why is it so difficult for the people that are asking for the deviation and have the burden to prove it? Why is it so hard? Back to being a practitioner. When people come to me, I say to them, an upward deviation is hard to get. And let's look at some of the other reasons why an upward deviation would be denied. And let's assume that I represent mother and father is the wealthy party on the other side. Does he pay for anything else? Did he agree to pay for a car? Did he agree to pay for private school tuition? Did he agree to pay for expensive summer camps? Does he participate? Do you have equal parenting time? Do you co-parent? Does he voluntarily agree to pay for activities for the children? Does he do the things that he has to do to financially support his children? And if the answer to that is overwhelmingly yes, the chances of you getting an upward deviation when you have a parent out there that's willing to pay for the extras, the private schooling, the summer camp, he's willing to participate, he pays for extracurricular activities when requested, doubtful you're going to get an upward deviation if you've got a voluntarily involved, interested, financially supportive parent. But when you've got what you have here, you've got a father that does not dispute that he makes $750,000 annually. He does not dispute that he does not pay for anything more for these children than what the orders have required him to pay. He concedes by quoting mother's testimony that he has paid just the specific amounts the court has ordered him to pay and no more. He does not dispute that he refuses to agree to the children's participation in any activities because by not agreeing, he gets away with not paying his share.
Counsel, let me interrupt you for a minute.
Yes.
You're making a very compelling case and very persuasive case, but we're a court of review. So tell me what my standard of review is, and tell me how the trial court abused its discretion, which is what I believe our standard of review is.
So this court needs to look at NIA, and NIA says basically,
Okay, please answer my questions in order. What is our standard of review?
your standard of review is that mother has the burden of proof to demonstrate that this upward deviation is necessary. It's an abuse of discretion if the court,
So abuse of discretion is our standard of review.
it's an abuse of discretion if the court makes decisions that are contrary to the evidence that was submitted at trial. And it is
So we just get to reweigh the evidence?
no, you're not reweighing the evidence, but when you look at the overwhelming evidence that mother presented at trial, and all of the details that were given, and all the exhibits that were admitted, and all the testimony that was given about how father shirks his financial responsibilities to these children, and then the court turns around and says, no, you don't get a penny more than what the child support guidelines give you.
Did
That
the
is an
guideline
abuse of
calculation
discretion.
at the time of the modification request, this modification
I'm sorry.
request? Am I correct that the guidelines actually would have called for a lower amount at the time that this modification request was?
$100 lower. And when the court fails to properly apply the statutory authority of 25-320, it commits error.
In what way?
Say that again?
What do you mean that it failed to apply the statutory authority of 320? I don't understand what you just said.
So the upward deviation, the standard is that if the child support guidelines meet the needs of the children, in order to deviate, the court must find that the application of the guidelines is inappropriate or unjust in a particular case.
So how is it unjust?
It's unjust because forcing mother to live within the confines of just the child support guidelines, the $2,600 and some change that was ordered in this case, given the overwhelming evidence that she presented at trial, that father does not contribute to any extracurricular activities. He does not help with any summer camps. He does not do the things that parents with significant wealth do in financial support of their children. For example, anytime mother requested father to pay for laptops or volleyball camps or tennis lessons or swimming lessons or private lessons for volleyball or clinics for volleyball for these 3 teenage children, he just said no. In fact, most of the time he didn't respond.
Is it your position that the amount of child support ordered is not sufficient to meet the children's needs?
It's not sufficient to meet the children's need, and the application of those guidelines to this case are unjust. They're inappropriate and unjust. And given the overwhelming changes of circumstances that led to the change of legal decision-making, giving mother sole, and the changes of parenting time, you realize that in the 2014 and even in the 2020 hearings regarding child support, father was regularly exercising parenting time, and these kids were 6 years younger. So fast forward to 2020, now father's exercising no parenting time with the 2 girls. And with the party's son, all of his parenting time is purely voluntary. It's optional. He can decide not to exercise the parenting time. So that turns out in mother having potentially 3 teenage children, full-time, 24/7, 365 days a year, and father now can simply shirk any additional financial responsibility for the children, for their activities, for any summer camps, for anything extra they want to do, by simply saying, no, I don't agree that they do that. And then he doesn't have to pay. at least before, father had an obligation to pay his 80% share for any agreed-upon activities, and implicit in that, as practitioners, we tell our client, you can't withhold your consent unreasonably. Now, this court, the lower court, completely abolished that rule and said, in fact, Mom, you can enroll the child in anything you want, but if father doesn't agree, you have to pay 100% for it. So all father simply has to say is no. And in multiple emails that were delivered at trial in the exhibits that were referenced in the opening brief, time after time after time, mother would ask and father would say no. Mother would ask and father would say no. So for the court to shift gears on mother, restrict her to child support just to the guideline amount, deny her any upward deviation, and then turn around and on top of that, deny her the right to get an 80% contribution for activities unless they're agreed upon.
80%.
I'm sorry?
That's not part of the appeal. We can't change that. The issue of whether or not, their division and their agreement that it would be, it had to be a bilateral agreement or the parent had to pay on their own. That's not before.
No, but what is before the court is the fact that father can deny any sort of financial contribution towards these activities by failing to agree to it. So they have to be agreed upon in order to get his financial
But
commitments.
the issue of reasonable agreement also isn't before. She didn't bring that to us.
That's correct. But it goes right back to the fact that because now father can, again, just deny, well, he could deny agreement before as a means not to pay. But now he can just deny the agreement and mother has to pay 100% of everything. And that goes to the fact of why an upward deviation. That's another fact that the court should have considered when deciding whether to grant this upward deviation. It's a different thing than in 2014. And when you look at all of the...
Do we know that the court didn't consider that?
Say again?
How do we know that the court didn't consider that and reject it?
The 2020 court?
Yes.
Well, why would a court...
I mean, based on the, as I understand our standard of review, back to my original question, is we view the record in the light most favorable to sustaining the finding of the trial court.
But that issue, excuse me.
So let me finish my question.
Oh,
if you
sure.
don't mind. And we also presume that the court knows and applies the law. That's a general principle of the law that we as a reviewing court. And I'll tell you, if I were deciding this first instance, I would have ruled in your favor. I would have granted an upward deviation. But that doesn't seem to be our job here. And so how do I know that the court didn't consider things that you think it should have? What is the error of the law? What is the real fault that we can pin on the trial court below?
Because the Mia case tells the court, you have to renew the case. You have to review the case anew. And regardless of whether there was a prior upward deviation or not, you have to give this case a first look on the information that's presented to you at trial. And we did that. We gave the court every single thing it needed to make a decision on these facts in 2020 at trial. And the court didn't do that.
So the error is that the court referenced the fact that it was the third request? Because I don't see anything in its ruling that it says, I'm applying a presumption. And this would make your job very easy if the court had said this, but there's nothing in the record or the ruling that says, I'm rejecting this because this is your third request. Is there?
No, it's pretty darn close.
Okay, well, tell me what your best argument that the court improperly applied some presumption against a modification in this instance.
This is the third time that she has made a request. Her request for an upward deviation was denied both times she requested in the past. The court has considered mother's third request for an upward deviation and declines to grant that request. The court's findings, so Judge Norris's findings on page 6 of the 2014 order, are well-reasoned and that same reasoning holds true today. That's impossible. That is an impossible statement for the court in 2020 to make when the changes of circumstances are so dramatic as compared to what was happening in 2014. It's impossible that there was not, that to take those relatively pretty inflammatory statements that Judge Norris made in his 2014 ruling against why a deviation was not applicable then, and to drop them down into a 2020 set of facts that doesn't even resemble what was happening in 2020. Not even close. And so in violation of NIA, instead of the court looking at this, making no presumptions that because it was granted before or it wasn't granted before, we got to look at this fresh, we got to look at this new. I got to look at the change of circumstances that are present today, and I have to make a determination of whether a mother has met her burden, that the application of the guidelines is unjust. There's no question she met her burden. There's no question the court did not review this case anew.
But the court actually said it applies equally to that. Isn't that the court saying, okay, I did look at it, granted somebody else wrote it before, but I conclude as a judge that it applies equally.
And that's where the abuse of discretion comes in. That statement, that those same inflammatory remarks made in Judge Norris's ruling in 2014 apply equally today, that's where the abuse of discretion comes in. The overwhelming evidence is against that.
Counsel, you asked to reserve some time. I don't know if you still want to.
I will. Thank you for reminding me.
Thank you. Go ahead, counsel.
Good morning. May it please the court, Carlos Noel on behalf of Applee Wayne Cumbria. Your Honors, to begin, I think there's two notes I'd like to make. Number one, prior to trial, neither party requested findings of fact or conclusions of law. In Judge Coffey's scheduling order, it notified both parties that it could do that prior to trial, specifically on the issue of child support. That did not happen. So under NIA, once the court found that the guideline amount was appropriate, it did not have to make any findings regarding the deviation factors in 320D. Number two is this court's deference to the trial court with respect to weighing evidence and assessing the credibility of the witnesses. I think that's very important in this case when you look at what mother alleged in the petition and what ultimately the evidence was at trial. Now, with respect to the trial court's order, if you look at the order, number one, the court did modify legal decision-making in parenting time. So that triggered the court's requirement to review the child support under 503 and 327. Not any question of it. Number two, the court found that it's mother's burden to demonstrate that the guidelines are unjust or inappropriate and to show that a deviation is appropriate. The court, in its order, found that mother failed to meet her burden of doing that. The court heard evidence and it heard testimony, or the court admitted evidence and heard testimony from both sides at trial, and the court found that mother didn't meet her burden. Moreover, the court specifically found that mother did not meet her burden to show a deviation in any amount was appropriate.
I'm a little confused about the court's order below because at one point it found that there was a material and continuing change of circumstances justifying decision-making, but then also found there wasn't a material change in circumstances, continuing material change of circumstances for purposes of a deviation request. So how can we reconcile those two? It almost seems like the order itself is in conflict with itself.
Yeah, that arises, Your Honor, from and I believe it's Guideline 24, which deals with modifications. And in Guideline 24, it's simplified modifications, the 15% threshold amount that is required to file a simplified modification. And in the guidelines, it says that 15% can be evidence of a substantial and continuing change in circumstances. Now, once the trial court went through
But
its
it
own...
doesn't say that that has to be, I mean, for the simplified it does, but generally that, it doesn't require, there's no law or guideline that says you have to show 15 before you can ever qualify for a change.
Agreed, Your Honor, and that's why, I mean, technically speaking, the order should have gone down. Once the court determined that the guidelines were appropriate, both worksheets that were submitted by the parties were less than what father's current child support is. So, if anything, mother benefited from the trial court basically saying since the amount is not more than 15%, then we're going to keep child support the same. Father is technically paying a higher amount slightly than he would have under either worksheets that were submitted.
Well, at the same time, he's refusing to pay for any of normal kind of extracurricular activities you'd see for teenage kids at the time.
Well, that's not
I mean,
necessarily true.
there's no real dispute in the record that he has washed his hands of anything but the bare minimum legal requirements for his children, right?
Well, let's look at that. So the guidelines are designed to provide for children's reasonable needs. So that's in the guidelines, and the presumption in the guidelines is that the guideline is sufficient to meet those needs. Now, in requesting a...
But let's revisit that, because the guidelines also currently stop at 20,000. And father's far exceeds that. When you put the combined incomes, it far exceeds the income that is the cap. And that's what triggers the liquidation, doesn't it?
That's correct.
Okay.
Yeah.
And so, it's a significant amount. This isn't a mother who's asking to deviate from the standard in a case where the math has been done to reach this. This is just, the state has picked that number under the guidelines because of economic reasons and data, that we're not going to more than the combined income of 20,000. Is that a fair assessment of what the guidelines do?
Yes, Your Honor.
Okay. And then you get to when you get to section 25 and looking at the adjustments, that substantial changes for the standard procedure, the 15% only applies to the simplified procedure. So the court isn't restricted in modifying. I think you were making that.
Yes, Your Honor.
Okay. So how is it not an abuse of discretion when father's income, when the combined income is in fact, I'm trying to think, something in the neighborhood of $45,000 more per month than the highest amount included in the child support calculation?
And that's where this court has to give deference to the trial court. The
Okay,
court
that's where I'm headed.
the court had heard evidence, and the court is under no requirement, the trial court is under no requirement to make findings regarding each one of those factors in 320D. So the court found that, and I understand that this isn't a court that's going to review evidence, but if you look at the petition, mom made allegations that she couldn't afford a trip to California, let alone Disneyland. The evidence at trial was she took trips to Hawaii, Missouri, Colorado, and then even emailed father, I think the year before filing her petition, saying, hey, can we switch parenting time days so I can take the kids to Disneyland? Mother requested, during the pandemic, the children were in virtual school. Mother said, hey, our son needs a computer. This is what he wants. It was an Alienware top-of-the-line gaming computer for virtual school. Father said, well, how about some Chromebooks? Mother said, no. And basically, so there's definitely a difference in lifestyle between the two parties. That's one thing that the court analyzes. And certainly...
So you're saying, well, we don't reweigh the evidence. We do look to see that there's at least some evidence to support the court's ruling.
Yes, Your Honor.
You're saying there is evidence to support the court's ruling.
Yes, Your Honor, and I think the order is clear. If you were to take a pen and just strike through the two sentences in the trial court's order where it says, yeah, and in addition to mother not meeting her burden today, I find that some of these things still exist today that happened back in 2014 regarding the allegations that were made and the evidence that was provided. If you were to cross out those two sentences regarding or referring to the 2014 order, would we be here? I don't think we would be, because the court analyzed the evidence. The court found mother didn't meet her burden. The court specifically found that no amount of deviation was appropriate. And what it comes down to is evidence. And mother and through opposing counsel makes a lot of conclusory statements regarding, well, there was ample evidence in the record regarding this need and whatever, but if there was actually an amount that here is why 2680 or whatever, 2680 is not sufficient. Here's what it costs to do this. Here's what it costs to do this. Then maybe this is a different case. But I challenge this court to look at that, and it's not going to be anywhere. It's not in the briefs because it wasn't admitted at trial. In the other big deviation cases like Nash and I think Bowe is the other one, yeah, there's CPAs who were involved, and it dealt with continuing the lifestyle of the parties. They were actually both dissolution cases. Continuing the lifestyle of the children post-divorce. And you had testimony saying, here's what it's going to cost to maintain that lifestyle for the kids. That's nowhere in here. Now, there's no basis for mother's request for $6,000, which she made at trial. And there's not even any evidence that shows why the reasonable needs of the children aren't being met just with the guideline amount, the 2680, that's the guideline amount. With respect to Nia, this is almost like a reverse Nia case. So Nia and I forget the other case, but both dealt with modifications where the previous order was a deviation. And the court began with the presumption that since the parties had a deviation in the past, then that's where we're going to start as far as determining the obligation today. Now, under the guidelines, the presumption that the court has to begin with is that the guideline amount is appropriate to meet the reasonable needs of the children. So it's a...
Where does that presumption come from? I don't read that in the guidelines.
It's in Guideline 3, Your Honor. So Guideline 1 states that...
Oh, you're talking about just the general presumption?
Yeah.
That the guideline amount is reasonable. Okay. I thought you were saying somehow for the deviation, it was something different.
No, no. You're right. It's in the guidelines, and when the court starts from there, and then the court has the burden of the party who is requesting for a deviation from the guideline amount, has the burden to show that the guidelines are unjust or inappropriate. She did not meet that burden. The order is very clear on that. There can't be abuse of discretion when the court heard testimony, admitted evidence, and found that she didn't meet her burden. Again, as this court's already said today, it's not this court's responsibility to reweigh evidence at trial. So getting back to Nia, the court, again, is starting with a presumption that the guideline amount is the appropriate amount. Now, after it went through the analysis, and it said, oh, hey, by the way, this is the exact same thing that happened in 2014, and I find that a lot of these things are similar, that's the law of the case. I mean, there's plenty of case law where courts can go back and look at incomes, historical expenses when determining child support. Just because the court said...
But if we treat it as law of the case, that runs afoul of Nia. I mean, Nia tells it needs to take a new look at it, so I think you're treading on dangerous ground.
Well, yes, I think you can do both. I think you can take a fresh look at a case, but there's history in every case. In all these child support cases, you might have a case that spans 18 years or more, just due to the age of the kids aging out. So if there are issues with a party's credibility, like I believe there is in this case, and previously there was allegations made regarding, well, here are all these things that I need and I can't afford, and the court found that not to be credible, the court can certainly say, yeah, I don't think anything's changed. I've looked at this, and honestly, nothing has changed since the last time we were here in 2014. That's not Nia. Nia starts with a presumption, and then begins the analysis from there. In this
I
case,
just want to challenge one idea and pick at it, which is the court has to decide credibility based on the witnesses report, not based on previous findings of credibility. Wouldn't you agree?
yes, Your Honor.
Okay. Because the way you just said that, it sounded like the court could rely on previous findings, that someone wasn't credible in the report.
No,
The
and that-
evidence wasn't credible.
no. In this case, I think, Your Honor, the court found that her testimony was incredible, and moreover, there was no evidence regarding how much does mother need in excess of the guideline amount to meet the children's reasonable needs. There's no mandate anywhere in case law or the guidelines of the statute that if one party makes more money, then they have to pay for everything that the other party wants. There has to be a balance and allow that other parent to say, no, I don't agree with that. Or in this case, where a lot of the extracurricular activities actually interfered with father's parenting time. So of course he would object. There was a lot of evidence in the record regarding specifically volleyball. Father lives in Lake Havasu. Mother and the children live here. And that volleyball would regularly interfere with his parenting time. So there has to be some kind of allowance for the other parent to say, one, no, I don't agree with that because it affects my parenting time. I'd like to see my kids. And then two, also a parent can...
But at this point, that's really not a fact. He's not seeing the girls at all. So I don't know how that's a fact.
I would also encourage you to tell your client to quit making expressive gestures in the gallery.
Yes, Your Honor. Oh,
I don't think,
Oh, I'm sorry. I thought that was your client there.
no.
sorry.
I apologize.
No, it's, getting back to,
So my point was, interference with this parenting time is not a basis for not doing the camp at this point, or the volleyball, because he's not seeing the girls.
well, part of that is speculation. Now, under the order, there's no requirement, there's no ordered parenting time. And father was very clear, he still loves his children dearly and would like to have a relationship, but he didn't want to basically have a therapeutic interventionist and have a big court process with two teenage daughters. He just thought, I've talked to them, this is what they want right now, I'm going to work with them. But at the end of the day, I don't want to exacerbate the situation. Thank you, Your Honor. Again, this case would be different if either party had requested findings of fact or conclusions of law prior. Maybe then we're not trying to guess what the trial court did insofar as its analysis of the guidelines in the statute. That didn't happen in this case. Now, one of mother's other appeals is that the court denied her post-judgment motion to alter or make new findings of fact or conclusions of law. Now, that by statute is permissive. Prior to trial, the court shall make. After trial, the court may make. So the court, in basically determining that it wasn't going to do that, there's no abuse of discretion there. That's certainly within its rights to do. The last thing that's on appeal is the attorney's fees. Again, there's no mandate that if a party makes more money than the other, that attorney's fees are required. Myrick v. Maloney, the disparity of income alone is not sufficient for a court to require the payment of fees. The court found that neither party acted unreasonably and that there was a disparity and that in light of the total circumstances of the case, neither party was going to pay the other fees. Both parties requested fees at trial. Again, that's abuse of discretion. I think this court has to defer to the trial court's discretion on that. It's the trial court's ruling on that, excuse me. I have about 2 minutes, so are there any other questions, Your Honors?
Thank you, counsel.
Well, in light of that, thank you, Your Honors. I'd ask again that this court just affirm the trial court, and then I'll just give up the rest of my time.
Thank you. Go ahead.
Thank you. I'll use my
Last 4 minutes and 10 seconds. Every bit of it. And I have to say, it's good to be back in a courtroom. The one thing I want to say in response to Mr. Noel's mention of the Nash case is that the Nash court held that we hold the Superior Court in a case of a dissolution of marriage of two persons with considerable wealth. The court may not limit child support to an amount required to meet the children's minimal needs. And I think that's exactly what this court did here. It restricted mother's child support. It allowed father's payment of child support to be just what the guidelines. And to your point, Judge, at the maximum of $20,000 a month, it stopped it there and said that's it, it's enough. And if you go back to Judge Norris's ruling that this court adopted, it said, mother is receiving more than enough child support to pay for father's portion of the children's reasonable living expenses, including but not limited to extracurricular activities. And didn't even make the connection that in 2014, these kids were 6 years younger, that they weren't teenagers, that they weren't involved in a lot of different activities, that there were not a significant change of the circumstances that all impacted the finances. Every single one of the changes of circumstances that mother brought to the court's attention at trial impacted the finances of this case. And I'll just mention some of them to you. Mother's testimony about travel, educational needs, extracurricular activities of the children and the costs and expenses associated with them. Father refused to pay for them. Significant and ongoing changes in parenting time, the financial circumstances since the 2014 modification. The children were 6 years older. Father's parenting time with the children had dramatically changed. The two girls with that father had no parenting time had started to play competitive club volleyball and tried out for their school teams and club teams. They wanted private clinics. The son had tried a number of sports, had recently joined a club team. She testified how she wanted to continue his school-associated strategy club that involved expensive purchasing and building of models. She testified to the changes in their school lives and the needs associated with that. She testified to father's unique European culture, family heritage, and the children's close bonds with the family, and their desire to go and see that family, and father's parents living in Canada, mother's facilitation of those kids staying in touch with the paternal grandparents. Even though father had an estranged relationship with them, mother came out of pocket through her very generous husband on many of these things that we just talked about. That is a side factor, but it's a factor that has allowed these kids to continue to do things despite the fact that father has shirked his financial responsibility. That can't be overlooked. She paid for them to visit father's parents in Canada. She wanted to pay for them to visit the family in Croatia and see father's roots. She testified that there were financial constraints that restricted the children from engaging in certain activities. She testified that the son had showed promise as a swimmer and that he liked swimming, and he was excited about finding a sport that he liked, and she liked the fact that he was getting out of the room and not playing Game of Thrones or whatever the video game of the day was. There was testimony about the children needing laptop and other electronic devices father refused to pay. She talked about the son's educational needs and tutoring. There were emails.
Counsel, real quick, wrap it up. Time's up.
Sorry. There were emails about the child needed math tutoring, and father said no. So, and attorney's fees, Your Honor, it's all been well briefed. Your Honors, it's been well briefed. I just ask that you grant this.
Counsel, we thank you both for your written briefs and for your argument here today. We'll take the matter under advisement and issue a written ruling in due course, and we are in recess.
Thank you, Your Honors.